I did that. I just made a stupid mistake. I knew I had a warrant for my arrest, and I just ran.
Judge, this wasn't just a stupid mistake. This was, they clocked him at some points up to 105 miles per hour. He lost a tire, was riding on the rim. They tried to throw out spikes to stop him. He just kept going around everything. And they finally had to actually crash into him with another vehicle to get him to stop.
Right?
Seen the video.
Oh, you did? Oh. And as you fled, you ran over the police officer's foot. The 108 miles an hour does a lot of damage to people when you get hit by a car. And probation is here. Oh, first amended, I guess, is what.
Yes, sir. And on the First Amendment, it's got an offense. 5 and 6 are actually the same evading. They're two different counties. I think I can only charge one. So we'll do number 6, which is in Jefferson County. That's the one he's pleading true to on these. The aggravated assault on a peace officer is the one we're going to have to try.
Okay.
So we're just going to plead on one of these because that's actually the same offense going through two different counties on 5 and 6. So we'll plead on 6.
We now call. Everybody ready? Clause number 21-37687. The state of Texas versus Tony, is it Tyrell Duhon?
Yes, sir.
The defendant is present with dismantling his fine attorney and the state's attorney. Does the defendant waive a formal reading of this first amended motion to revoke probation, which was filed June 16th of this year? Can we proceed in summary?
Yes, sir.
And Mr. Duhon, raise your right hand. Do you solemnly swear or affirm that the testimony that you were about to give in this hearing will be the truth, the whole truth, and nothing but the truth? So help you God. Lower your hand. In summary, this motion states that and it's a first amended motion to revoke probation, states that on January 19th, 2022, that would have been going on 2 years, almost 2 years ago, that you were sentenced to 10 years in prison, probated for 10 years for evading detention with a motor vehicle, which was a third-degree felony. Is all of that true and correct? That's true. You were sentenced to 10 years, then that was suspended and you were placed on 10 years probation. Number 5. Number 6. We're going to do 6.
Yes, sir.
Number 6 allegation states you committed the offense of evading arrest or detention with a motor vehicle on or about April 14th, 2023 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue?
Yes, sir. True.
Are you pleading true to that allegation?
Yes, sir.
Voluntarily, and because it is true as it is alleged?
Yes, sir.
Do you understand by a knowing and voluntary plea of truth to one or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can now be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
Is there a need to go to any others?
No.
Okay. I do want to hear from the probation office a summary of other, notwithstanding violation allegation 6. What else can you tell me about Mr. Duhon's time here?
Yes, sir.
There's no deal on this, right?
Correct.
Okay.
Mr. Duhon was placed on probation in January of last year. Since being placed on probation, he reported to the office a total of 9 times, which ended September 6th of 2022. Since then, he has not reported in person to the department.
Since when?
September of last year.
Of 2022?
Yes, sir.
He's been a goner? Or he's
Yes,
been
sir. He
absconded?
And how long have you been in jail?
No, it's in April 14th.
April.
Yes, sir.
November through April.
Did he ever try to explain that?
No, not to me, Your Honor.
Well, excuse me while I even breakfast and lunch here. It's been a very hectic day. And I'm eating popcorn.
January 5th.
You're really not on probation if you're not touching base with us and supervised.
Yes.
I mean, it's really not. It's kind of a joke, and it's not actually supervision, which it's futile for us to have a probation office. You don't report. You have to touch base all the time, and we keep you. Not only are we keeping an eye on you, we're reminding you about all the rules and the consequences of breaking the rules. And the problem here is you're on probation for evading detention with a motor vehicle. And so what do? You go out and commit another crime as though you're not contrite about the first mistake. And the law provides that these are third-degree felonies because when you're evading, I don't know if you were searching with a motor vehicle, we're talking about cases here that it's not unusual for us to have people fatally injured, seriously injured in car crashes because they happen to get hit by vehicles that are involved in fleeing from an officer. It's very dangerous. It really haunts us all for the rest of our life. It haunts us to hear the lamentations of people who go, we were just following the rules. We were minding our own business. And then this car comes out of nowhere at 120 miles an hour and kills a bunch of people. That's what happens. And then you go, what can you do about that? You can't undo it. We can't go back in time. But you had to have recognized how important it was the first time we made a big deal about it and then placed you on regular probation because of the serious nature of all of this type of offense. Do you happen to have pre-sentence report I can look at really quick?
Yes, sir.
I'm not surprised what I'm reading here. In your criminal history, in the misdemeanor part, for example, you got an assault. How old are you right now?
35.
You're old enough to know better, but back 15 years ago, 18 years ago, actually 16 years ago, you committed the offense of assault, and that was a misdemeanor conviction. Failure to identify in 08, that was a conviction. Trespassing in 08, that was a conviction. Family assault, and that was in 2010, that was a fine. But here's what I'm leading up to: evading arrest or detention in 2015. And 60 days in jail. So we're serious about that. 60 days in jail. But you go back and you commit in 2021 evading detention with a motor vehicle, and then sentenced to 10 years. We made bigger deal about it. 10 years in prison, probated for 10 years last year. And so now you picked up a third evading. And this one's second one with a motor vehicle. But I'm not even including these failures to appear, contempt of court, traffic offenses, violation of school compulsory law, possession of drug paraphernalia. I mean, all of those are just all things that just show, hey, I don't take this seriously. And you have to, like I have to. We all, so that we can all live together on this increasingly small planet peacefully and enjoy what our dreams are. But here you are, is back before me for the same offense, third time. This could have been such a catastrophe. They stop you for expired registration. See, you're not even driving a vehicle with the proper procedure. Everybody else has to pay for inspection stickers and registration, but you're because it's a privilege. There, you look in the Constitution what that flag stands for. You won't find you have a right to drive a car. You won't find it in there because it's a privilege. It's not a right. But you got to pay for the privilege, like everybody else does, for the cost of the roadways and the maintenance, the security, so that we can all enjoy it together. So you were asked to step out of the vehicle. You refused, fled, and as you fled, you ran over the police officer's foot.
And,
My
and
God.
that's the one that we're not reading on at this particular hearing.
Okay, okay, he does,
pointing that out.
but the next sentence completes the thought. A vehicle pursuit ensued through Port Arthur and continued in and through the city limits of Beaumont and on to Chambers County. So I'm sorry, but this was 8th Avenue in Port Arthur that this happened, not Chambers County. This is Jefferson. This is the one he pled to. But even if he didn't, this was a series of acts that began in one county and ended in another county, so they're connected. I mean, isn't that true? This is what we're talking about, Port Arthur, Texas, that you pleaded true to here in number 6 in Jefferson County on April 14th. He received medical treatment. Well, this doesn't look good, obviously. I mean, not only did you do the third thing wrong that we'd already sanctioned you for 3 times, but you ran over, you injured a police officer. My goodness.
I didn't do it. It's on the video. It clearly shows that I didn't do it.
He is maintaining that he doesn't believe that he ran over the officer's foot.
All
right.
I seen the video.
Oh, you did? Oh,
He didn't have an injury on his
Okay.
foot at all.
all right. Let's walk it back. Let's say you didn't drive over. What are you doing? Leaving the scene and running from the police? Do you have any excuse for that?
No, sir.
All right. It's a crime. It's a crime. My goodness, it's a felony on my watch. After you had gone AWOL on us. That again is something that the court doesn't find amusing. We have 5,000 probationers. We can't go and find you and ask you, please come back. You have a responsibility that you signed off. You made a promise to me. Let's see. Here's your signature, Tony. I've received a copy of this order. I agree to follow all conditions imposed. I know that this probation can be revoked for any violation. You knew how important it was. So, what do we do? What's the defense asking for?
We're asking, first of all, he would like to have the opportunity to stay on probation. And even though he realizes he's facing at least the one felony and a second one that he's contesting so far, but he would like the opportunity to stay.
That other one in Chambers County, I wouldn't.
No.
I don't think they're going to pursue that. I know it's in the same, wrapped up in the same transaction.
Yes, sir. The law states that we can only, it's one continuous act, so it can only be charged one time. So it'll just be the one evading.
But we're all clear. It happened here in Jefferson County.
There is the
aggravated here in Port Arthur.
Aggravated assault on a peace officer.
My old birthplace. And so we're involved here deeply in the safety of our county.
Yes, sir. And if the court were not inclined to allow him to stay on probation, then we would ask that you consider something that may be on the lower end of the punishment scale, the 2 to 10. He still is facing the aggravated assault case. And, depending on how that comes out, it may affect the length of his time that he might be sentenced today. And did you have anything that you wanted to add on your behalf of why the judge would leave you on probation?
Yes.
What about that probation, the aggravated assault probation?
No, it's a new case.
No, there's a new case, aggravated assault. There's a family violence and this
That's
evading
family
detention.
violence. What
Right.
about that?
We filed a motion in it too. I thought.
Yeah.
It's.
Are we dealing with that today?
Yes, sir. It's
okay.
It's right there underneath your filing. So I think it's there somewhere.
Right here.
Two cases, you want probation.
They're both 10 over 10, both third degrees.
Why don't we go over that one too? We'll hold this one in abeyance and go to 21-37688. And again, you were still under oath. And does the defendant waive a formal reading of this first amended motion to revoke probation? Can we proceed in summary here?
Yes, sir.
In summary, sir, this motion states that on January 19th, 2022, the same date as the other probation evading detention that we've already dealt with here earlier, that you pleaded guilty and were sentenced to 10 years in prison, probated for 10 years for assault family violence. Is that true?
Yes, sir.
And it's the same. Number 6 is alleged here that you committed the offense of evading arrest or detention with a motor vehicle on or about April 14th, 2023 in Jefferson County, Texas, in violation of number 1 that you had signed off on that probation order, don't commit another crime. And you violated that condition of probation. Is all of that true as it is alleged?
Yes, sir.
Are you pleading true voluntarily and because it is true?
Yes, sir.
You understand by pleading true that is enough?
Yes, sir.
One or more violations are enough to grant this motion to revoke probation, the first amended motion to revoke probation, as I would find by a preponderance of the evidence. There is enough evidence to do so. Your probation can be revoked and you can be sentenced as the other case, no less than 2 nor more than 10 years confinement in prison. Knowing that, you insist on pleading true today.
I do.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
Anything else? you wanna have?
Just further, we would ask.
What is your envision of how this should proceed?
First, did you want to address the court about if you were willing to let you stay on probation, what your plans are?
Yes, ma'am. Well, first off, I had sympathy for the officer if I did, injure him. And second, I was really doing good. My mom passed like September 25th, 2022, and I took in my sister. She's 14 years old. And that day, I just made a stupid mistake. I was doing good. I was working, and I just had a lot of stuff to take care of after my mom passed. So I just stopped reporting. I really don't have no excuse.
And what was it that you're saying that happened that kept you from being able to complete your probation requirements?
I just had a lot going on. I didn't really have the excuse. Like I said, my mom passed. I was trying to get funeral arrangements going. It was a lot. And then when I called up there,
Well, when did your mother pass?
September 25th,
Of what year?
2022.
A year ago, last year.
Yes, sir.
Okay. Keep going.
Like I said, I was on the right track. I just made a stupid mistake. I knew I had a warrant for my arrest, and I just ran. I should have just
A warrant for what?
for the MTRP.
MTRP.
Yeah. God bless you. So what you're saying is that you chose committing another crime, fleeing, to avoid answering to another violation that was being alleged.
Yes, sir.
That's facing your responsibilities in a proper fashion?
No, sir.
No, it's not. That's why it's a crime, because that's not the way you're supposed to handle issues. All you did is you turned one problem into 2.
Yeah, I made it worse.
Yeah, you threw gas on the fire. But you knew it was, nobody ever runs forever. They know where you are ultimately. Even if you were able to escape, you're going to get caught.
Yeah, I know.
I mean, it's inevitable. I just can't. I don't know. That happens a lot. I have to face the issues. It would bother my conscience to death if it was, I wonder if somebody's going to walk up my door one day with with an arrest warrant for this. I'm not going to wait. I'm going to meet it head on and deal with it responsibly. But you've been through this before.
Yeah.
You know how to handle it right versus wrong, but you keep doing it the wrong way. What's next?
Judge, this wasn't just a stupid mistake. This was, they clocked him at some points up to 105 miles per hour. He lost a tire, was riding on the rim. They tried to throw out spikes to stop him. He just kept going around everything. And they finally had to actually crash into him with another vehicle to get him to stop.
Is that all that true?
So we would ask for the 10 years. He's going to hurt somebody, and he needs to know that this is extremely serious.
What would you like to say, sir?
The only thing I'm guilty of is evading, but I do understand if
God bless you. That's not what you're only guilty
no,
for.
I'm saying by me running, I know I caused the police officer to get injured and stuff. Like I could have hurt a lot of people.
We were lucky. They were lucky, not because of you, but the good Lord was shining on and keeping an eye on the people, because the 108 miles an hour does a lot of damage to people when you get hit by a car. You can't. I mean, that's why speed limits are no more than, I think, 80 in the country. I don't think there's one higher than that, which is awfully fast. But still, vehicles most vehicles weren't meant to operate safely at anywhere near 100 miles an hour.
Again, I just ask the court to maybe consider holding the motions in abeyance, and he still has this felony to deal with. And then after he's done with that, maybe then it might make a difference on the rest of his probation. Otherwise, if the court's going to revoke his probation, we would ask for something. I don't believe the injuries, the assault family violence was definitely an assault family violence, but I don't think they were severe injuries. And I'm not sure about the evading. Was there a chase in that one? Did anybody get injured in that one? And so I would suggest that perhaps the underlying facts on those two original offenses that he's on probation for don't warrant a full 10-year sentence.
Here's the deal: is your actions speak louder than your words, because you promised me when you were placed on both of these probations that you wouldn't do something like this again, really. Because number one was committing a crime, and you know it's a crime. We made a big deal about it last time. Felony offense. So you went right back and did it. You signed off. You made a deal that it didn't take long before you broke with the same crime. If nothing further, I'm going to find in each of these two cases, and this is 21-37687 and 37688, the first amended motions to revoke probation, shall be granted by a preponderance of the evidence or greater, as allegation 6 has been proven true, as the defendant has voluntarily and knowingly admitted to condition 1 violation in each probation, and that is committing the same crime he is on probation for in 37687, the same type of crime, evading arrest or detention with a motor vehicle, which are serious third-degree felony. In each of these cases, sir, your probation is revoked, and you are now hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each case to run concurrently. You put this court into a corner that that you have a problem with, and that is committing the same serious offense, and it just gets worse with irresponsible behavior with a motor vehicle and with law enforcement. The rules don't seem to apply to you. But they do, but you don't accept them. You must pay a price at this stage for continuously putting yourself and others in harm's way. And again, these 10-year sentences shall run concurrently.
Before he's released back to the jail, may I have a few minutes to speak with him about the third case?
What number is that? That's CR 3474.
Sunny Yeah, 0374.
374, the state of Texas versus Tony Tyrell Duhon, who's present again with his attorney, Ms. Mantalini, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 14th, 2023 in Jefferson County, Texas, you committed the first-degree felony of aggravated assault against a public servant with the use and exhibition of a deadly weapon, namely a motor vehicle. Do you understand what you're charged with here?
Yes, sir.
This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be sentenced, pleading guilty, sentenced to 5 years in prison to run concurrently with other cases. Is that your understanding of the agreement? If I follow this, you have no right of appeal. Do you understand? How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered.
No objection.
It's admitted. Among other things, the state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement then and find you pleading guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony as indicted in this case 23 CR 374. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years to run concurrently with other cases. The judgment will show an affirmative finding that a deadly weapon, namely a motor vehicle, was used in the commission of this offense. Anything else?
Yeah.
That is all. Thank you.